Okay, let's dive in. Picture this. It's really quite shocking. One minute you're a mom with 5 kids, the next, they're gone. Just like that.
It's a nightmare scenario, and it's right at the center of this legal battle we're looking into today.
Yeah, we've been going through a ton of court documents, filings from Megan Miller, and they paint this picture of a Kansas custody case that honestly raises some really big questions about the whole legal process.
And I think what's crucial right off the bat is that Megan's filings, they're not really arguing about who should have custody in the end.
Right.
It's more about whether her fundamental rights, constitutional civil rights, were violated during the process itself. Was the system fair to her? That's the core question she's raising.
Exactly. So yeah, we'll touch on what kicked things off, but we're not trying to redecide the custody here.
No, not at all.
Our goal is really to pull out the key claims Megan is making, lay out the timeline as she sees it based on these documents. We want to hit the main points, the sort of aha moments, without drowning everyone in legal jargon.
Right. And there are a few key people involved we should mention.
Good point. There's Megan Miller. Obviously, she's the one bringing the federal suit. Then Randy McCalla, who was the guardian ad litem.
The GAL in the state case.
Then Julia Battle, a therapist. J. Stephen Hazel, a psychologist. And Johnson County, Kansas, is also named as a defendant.
Okay, so that sets the stage. Let's start with the event that triggered all this, the emergency removal of the children.
Right. According to the filings, this happened back on January 29th, 2024. 5 kids just removed from Megan's custody immediately.
And this was based on an emergency motion filed by the guardian ad litem, McCalla.
And that motion, as we understand it from the papers, it really relied heavily on a report from that therapist, Julia Battle.
Yeah, and the report contained some, incredibly serious allegations. Things like sexual misconduct, alcohol abuse, emotional manipulation, all aimed at Megan.
Okay, but here's where it gets procedurally interesting, right? This all went down in what's called an in-camera hearing, and it sounds like it was rushed.
Exactly. An in-camera hearing, for listeners who might not know, is basically private, in the judge's chambers usually. And Megan's filings really stress this. The judge looked at Battle's report privately, but she claims she wasn't given the whole report.
So she didn't see everything that was being used against her.
That's the allegation.
Yeah.
She says the judge just read out certain parts, certain accusations, and she claims she didn't get the full document or, crucially, a real chance to respond properly right then and there.
That seems problematic, the whole idea of seeing the evidence against you.
It's a cornerstone of due process, absolutely. And her filings also point out, very specifically, that this initial removal, it happened without any sworn testimony.
No witnesses under oath.
No, and no sort of tangible evidence presented in open court at that moment. It was all based on this private review of the therapist's report.
Okay, so the kids are removed on January 29th based on this hearing.
Right. And then the documents show a formal court order from Judge Kevin O'Grady came later on February 21st, 2024. That order basically formalized the removal that had already happened weeks before.
So the action preceded the formal order in a way.
It appears so, based on the timeline in the filings. The immediate removal stemmed from that in-camera review.
Okay, so that's the emergency removal. But Megan's story in these documents, it definitely doesn't stop there. She talks about having evidence that clears her name, exculpatory evidence, and alleges it was ignored or hidden.
Yes, and the timing she highlights is really striking. On the very same day as that January 29th hearing.
The day the kids were removed.
Yes. She says she passed 2 court-ordered drug tests, a hair follicle test and a urinalysis.
And the results?
According to her filings, they showed no alcohol, no illegal drugs, just therapeutic levels of medication she was prescribed.
Wow. Okay. So facing accusations including substance abuse, she provides clean tests on the day of the hearing.
And she alleges this evidence, which seems pretty crucial, was just disregarded, ignored.
That definitely raises questions about how all the information was weighed.
It does. And there's more. Before that January 29th hearing, she says a DCF social worker, that's the Department for Children and Families, Michelle Merritt, interviewed the kids.
Okay, standard procedure in these cases, right?
Usually, yes. And according to Megan's filings, Merritt found no evidence of abuse.
No evidence.
That's what's alleged. And apparently, Merritt's notes even suggested the kids' answers seemed kind of prodded, like maybe not entirely their own words.
That adds another layer of complexity to the information that GAL had.
And that leads to a really critical allegation. Megan claims that McCalla, the GAL, knew about these initial DCF findings before the emergency hearing.
Because as GAL, he'd have access to DCF info.
Exactly. That's part of the role representing the kid's interests, which usually involves seeing agency reports.
So what's the allegation? That he knew and didn't say anything.
Precisely. She alleges McCalla suppressed both her negative drug tests and these initial DCF findings during that January 29th hearing. Didn't tell the judge, didn't tell her side.
So the claim is that potentially game-changing information was kept out of the loop at that critical moment?
That's the essence of her claim about suppressed evidence, yes.
Okay, what happened with DCF after that? Did they eventually close their case?
Well, the filings state that DCF did confirm later, on June 5th, 2024, that their case would be unsubstantiated, meaning they didn't find sufficient evidence of the initial allegations.
Okay, so unsubstantiated.
But McCann alleges McCalla kept interfering with DCF supervisors.
Interfering how?
She claims his actions delayed the formal closure of the case. Significantly delayed it.
How long are we talking?
According to her documents, the official confirmation that the findings were unsubstantiated didn't come until January 22nd, 2025.
Months later.
Yes. And apparently, the DCF General Counsel, Mark Aldenburn, attributed the delay to an unintentional oversight.
An unintentional oversight? While a mother is separated from her kids, based partly on those initial, now unsubstantiated claims.
It's a very long oversight, if that's what it was. But then the story takes another twist.
Ooh.
Even after that confirmation, a new DCF report came out literally the next day, January 23rd, 2025. This one alleged emotional abuse, but based on Megan's social media post.
Based on social media?
Yes. And she claims this led to a retaliatory substantiation finding against her on March 18th, 2025. She's fighting that in a separate federal lawsuit now.
Wow. So it's like one issue gets resolved, potentially, and another immediately pops up linked to her speaking out online.
That's certainly the picture her filings paint. Very tangled web.
Okay, let's shift gears a bit. Another major area in her filings concerns therapy sessions and a psychological evaluation that she claims were unauthorized. What's the story there?
This part focuses heavily on alleged violations of court orders. According to the filings, the therapist Julia Battle.
The one whose report triggered the removal.
Yes, her. Battle allegedly conducted 69 therapy sessions with the kids between 2023 and 2025.
69 sessions,
Yeah.
Okay. And the issue is?
The issue, Megan claims, is that she was excluded from all of them. But her ex-husband and his wife were included.
And was there a court order about therapy?
Yes. She points to a February 13th, 2023 court order that specifically required joint parental involvement in therapy. So, excluding one parent allegedly flew directly in the face of that order.
Okay, 69 sessions potentially violating a court order. That sounds significant.
It does. And it apparently didn't stop there. Even after a different court order, on July 22, 2024, appointed a new therapist, a Dan Livingston. Julia Battle allegedly continued seeing the kids for 23 more unauthorized sessions.
So even after the court basically said, use this other therapist, Battle kept going.
That's the allegation in the filings. And there's a financial dimension, too.
Money.
Yes. Battle allegedly billed $3,230 for these sessions. Megan claims were unauthorized, and part of that, Megan alleges, was charged to her own credit card without her permission.
Charging her card without consent for sessions, she says, violated a court order.
That's the claim. Pretty serious stuff. And the invoices themselves, according to Megan's filings, might show more.
Like what?
She claims they show coordination between Battle and McCalla, the GAL, including lawyer communications billed before Battle's report, what was used in that January 29th motion.
Before the report that started it all.
Yes. And there's apparently also a specific charge tied to McCalla asking Battle for an updated report.
So the filings seem to suggest a closer working relationship than might be expected.
That's certainly the implication Megan is drawing from those billing records. It paints a picture of collaboration.
Okay. What about the psychological evaluation?
Right. This involved the other professional we mentioned, J. Stephen Hazel, the psychologist. He allegedly evaluated Megan on March 18, 2024. But, according to the filings, this was done at McCalla's direction, just via email.
Not a formal court order.
Megan claims McCalla's email falsely implied it was court-approved, but that no actual order existed for this evaluation.
So she went, thinking it was official.
The filings suggest she attended under duress. Her kids had just been removed, and Hazel apparently found the results inconclusive.
Inconclusive, so not much use then.
Well, despite being inconclusive, he still issued a report.
Yeah.
Megan claims this was done without her consent or even letting her review it first.
And that report was then used against her?
Yes, allegedly used against her in the custody case. So, questions about ethics, consent, and how that evaluation came about and was used.
Okay, so we've got alleged withheld evidence, therapy against court orders, and evaluation under questionable circumstances. The filings also talk about retaliation and gag orders. What's that about?
This section alleges that McCalla, the GAL, retaliated against Megan specifically because she was speaking out, exercising her First Amendment rights.
Retaliated how?
By allegedly pressuring therapists to slow down or delay reunification, linking it to things she posted on social media.
So using her online posts as a reason to keep the kids away longer.
That's the claim. And she says he filed a formal motion on June 9th, 2024, asking the court to restrict what she could post online.
A motion to limit her speech.
Yes, and she alleges the motion misrepresented her online activity, making private stuff seem public.
Did the court grant that?
The filings say the state court did issue gag orders. They were apparently in effect between June 9, 2024 and April 4th, 2025.
What did the orders restrict?
Her speech, generally. But they also allegedly included filing restrictions aimed specifically at her because she was representing herself acting pro se.
Restrictions on filing court documents. That seems like it would make it really hard to fight her case.
It could definitely be a major obstacle. The filings argue these orders were designed to silence her and hamper her legal efforts.
And there was something else about monitoring.
Yeah, an interesting little detail. Megan claims McCalla's wife subscribed to her business email list way back in 2021.
His wife subscribed to her business list.
Yes. Megan seems to suggest this points to a longer pattern of monitoring her activities.
Adds another layer to the retaliation claims. Okay, let's talk due process. Fundamentally, people need fair procedures and access to information in court. How does Megan claim that played out here?
Well, she claims she was denied due process repeatedly. For instance, she filed motions to try and undo that initial custody order.
Right, the one from the in-camera hearing.
Exactly. And she also filed to have McCalla removed as the guardian ad litem.
And what happened?
According to her filings, the state court denied both motions. Crucially, she says they were denied without holding any hearings.
No hearing, just denied on paper.
That's the allegation. No chance to argue why the order should be vacated or why the GAL, who's supposed to be impartial, should be replaced.
That seems like a denial of the right to be heard on really important issues.
It certainly raises that question. And then there's the issue of records.
Access to information.
Yes. She claims her repeated requests for relevant records using subpoenas, filing motions to compel, even making HIPAA demands for health information, were all refused by both McCalla and Battle. She argues these records are vital for her to understand the case against her and build her own defense.
Especially things like her kids' therapy records, you'd think.
Absolutely. Access to children's health records in a custody case seems pretty fundamental. Denying that, she argues, hampered her ability to participate meaningfully.
And what about getting therapy started to reunite with the kids?
That's another point of contention. The filings state that reunification therapy with the new therapist Dan Livingston didn't actually start until almost a full year after the kids were removed.
A whole year?
Nearly a year from January 29th, 2024. And this was despite, she claims, her filing repeated motions trying to get it started sooner.
A year is a very long time in a child's life, especially when separated from a parent.
It's a huge amount of time.
Yeah.
And it underscores her claims about delays and unfairness in the state court process.
Okay, let's focus on the state court itself. What specific actions by the court does Megan highlight in her federal lawsuit?
There are several key points. One really big one is that her trial, the actual custody trial, scheduled for April 2025.
Yeah.
It was canceled by the state court just weeks before, on April 1st.
Canceled? Why?
The reason given, according to the filings, was unpaid guardian ad litem fees, about $13,500 worth.
Okay, but didn't you mention she claims she's indigent? Like, she can't afford to pay?
Exactly. That's the crux of it. She claims she's indigent, and she also says the court had previously indicated those GAL costs would be sorted out at the trial, considering everyone's finances.
So canceling the trial beforehand because of fees she says she can't pay, despite that earlier understanding.
She argues it was fundamentally unfair and basically blocked her access to justice based on her inability to pay.
Yeah, that raises serious justice for sale kinds of concerns.
It does. Then there's the issue of court records access. She claims that for a while, her access to the state's online court system, e-court, was just denied.
She couldn't even log in to see documents in her own case.
That's the allegation. She argues this violated the Kansas Open Records Act.
Wow. Okay, anything else about the state court?
Yes. She has documented diagnoses, PTSD, ADHD, and something called litigation abuse syndrome.
Okay.
And she requested accommodations under the ADA, the Americans with Disabilities Act, to help her navigate the court process.
Standard practice, right? Courts have to provide reasonable accommodations.
They're supposed to. But she alleges her requests were denied flat out, without even a hearing to discuss them.
Denied without a hearing. That seems contrary to the spirit of the ADA.
It certainly raises questions about ensuring equal access for people with disabilities in court. And one more point, which is quite disturbing.
What's that?
She alleges the judge actually mocked her for bringing up Marsy's Law and VOBE, the Violence Against Women Act.
Mocked her for relying on laws meant to protect victims.
That's the claim in the filings. It's a serious allegation suggesting potential bias or dismissal of important legal protections.
If true, that's deeply concerning behavior from the bench.
Absolutely. It feeds into her broader narrative of unfair treatment within that state court system.
Yeah. Okay, so all of this alleged misconduct, these violations, it's all culminated in this federal lawsuit she's filed. What are the main legal claims she's making there?
It's a pretty extensive list. She's suing under several federal civil rights laws, 42 U.S.C. sections, 1983, 1985, 1986.
Okay, can you quickly break those down?
Sure. Section 1983 is the main one for suing state officials who violate your constitutional rights. Sections 1985 and 1986 deal with conspiracies to interfere with civil rights and failing to stop such conspiracies.
Got it. And she's also suing under the ADA.
Yes, for the alleged denial of accommodations. Plus, she's included state law claims like fraud, misrepresentation, and intentional infliction of emotional distress.
So a wide range of legal angles. What are the big constitutional issues?
A major one is a direct challenge to a Kansas Supreme Court rule, Rule 5.1c.
That's the rule about the in-camera review of reports.
Exactly. The one that allowed the judge to review Battle's report privately. Megan argues that applying this rule to her, without letting her see the full report or respond, violated her 14th Amendment right to due process, the basic right to a fair hearing.
Makes sense. The ability to confront the evidence seems fundamental.
It is. She's also claiming First Amendment violations freedom of speech.
Because of the gag orders and retaliation for her social media posts.
Precisely. She argues the court unlawfully restricted her speech and punished her for speaking out, including about her case on her website, standwithmeg.com.
Okay. What else? Conspiracy.
Yes, she alleges a conspiracy involving McCalla, Battle, and Hazel to interfere with her civil rights. And she claims this was partly driven by gender bias, or animus.
Alleging gender bias adds another serious layer.
Definitely. The suit also covers violations of her basic parental rights, being denied access to the kids' health records, and a failure by the defendants generally to prevent these rights violations.
And the ADA claim for the accommodations denial.
Right. She's challenging pretty much the entire state court process and the actions of the key players within it.
It sounds like it. Now, usually federal courts stay out of ongoing state cases, right? The Younger abstention doctrine.
Generally, yes. But Megan argues Younger shouldn't apply here.
Why not?
Because, she claims, the state case involves bad faith, harassment, and is causing irreparable harm. She specifically points to the alleged judicial misconduct as reasons why the state system can't provide a fair forum, justifying federal intervention.
So she's saying the state process is so flawed that the federal court needs to step in.
That's the essence of her argument against abstention. And she's also suing Johnson County itself.
The county government. On what grounds?
Alleging that the county's policies and customs regarding how the GAL program works, how fees are handled, access to court records, led to violations of due process and equal protection. Basically blaming systemic issues.
Trying to hold the system accountable, not just individuals.
Exactly. And procedurally, she's formally notified the Kansas Attorney General that she's challenging that state Supreme Court Rule 5.1c.
Okay.
And she's also filed for sanctions against McCalla and Battle under Federal Rule 11.
Rule 11. That's for filing baseless claims, right?
Yes. It's meant to deter frivolous or false filings. She's accusing them of making false or unsupported claims in the state court proceedings.
So she's using multiple tools to push back hard.
Very much so. The filings indicate a comprehensive legal challenge.
Okay, finally, what does she want the federal court to do? What kind of relief is she seeking?
She's asking for a lot, basically seeking to undo much of what happened in state court and get compensation. First, there's declaratory and injunctive relief.
Meaning?
She wants the court to declare her rights were violated. And injunctive means she wants court orders impelling action. like ordering her parenting time restored, ordering the release of all those records she wants, ordering ADA accommodations for any future proceedings, and stopping the defendants from continuing the alleged unauthorized actions.
So direct intervention to fix the situation as she sees it.
Yes, essentially asking the federal court to step in and correct the alleged state court errors and misconduct.
That's significant. What about money?
Oh, yes. She's seeking substantial monetary damages, compensatory damages for the emotional distress, physical harm she claims she suffered, and huge financial losses.
How much are we talking?
Her filings detail over $284,000 in losses. She can document or estimate things like lost child support she should have received, lost income, being forced to sell homes at a loss.
Wow, nearly $300,000 just in those kinds of losses.
Yes, and on top of that, she's seeking punitive damages.
Which are meant to punish the defendants.
Exactly. To punish alleged intentional harmful conduct and deter others. And she wants a jury to decide the facts of the case.
So the stakes are incredibly high for everyone involved. It really does underscore how serious these allegations are.
Absolutely. Megan Miller's filings, as we've laid them out, they really do raise some fundamental questions about fairness, due process, parental rights, the very integrity of the family court system.
And it's so important to reiterate, what we've discussed is based on her court filings, her perspective, and the facts presented within those documents.
Absolutely. It's one side of a very complex, ongoing legal fight.
The sheer number of legal and procedural issues tangled up here is, well, it's kind of staggering.
It really is.
So maybe the question to leave our listeners thinking about is this. When you see allegations this serious about procedural unfairness, about constitutional rights potentially being violated right inside the legal system, especially in cases that tear families apart, what does that mean for our trust in justice itself?
It's a heavy question. And for anyone wanting to dig deeper, the federal case number is 2.25 CV-21AD0 KHV-HAJ, District, Kansas. And exploring concepts like due process, First Amendment rights in court, the ADA, the role of GALs, it's all relevant here.
It definitely feels like this is just scratching the surface of a really complicated and frankly concerning story. It certainly makes you think about accountability and fairness within the whole system.